Good evening, everybody. Happy Sunday. Hope everybody is doing well today. Let me see if I can get it all adjusted here. Let's get all the settings set up. Hello, Flowtog. Hello, Richard. Hello, Ziggy. Good evening, James. Hey, we got a moderator in here. Hey, Kim. And Richard. Hey, from Hawaii. Hello, Kevin. Hello, Freddie. Hello, hello, hello. Thank you all for joining me on this lovely Sunday night. Hello, Carly. Hey, CeeLo, Richard, the other Richard, Chris, Elena. Woo, gosh, we got a lot of states in here. And a couple countries already. Thank you, Dean. Parakeet, Tammy. Oh, you guys came in for the show, huh? All right. As I was saying, let me get set up here. Smash that like button if you haven't already. We're going to have some fun today. We're going to talk about some fun stuff. We haven't talked about law in at least a month. So we're going to have some fun today. Studying for the bar. Hey, James. Good luck, man. Whew. Sitting for the bar is going to be a whole new deal. Hey, New Mexico. CDL driver here, Richard. You're going to learn some good stuff today. You're going to learn some good stuff. Another someone sitting for the bar. Man, good luck, James. That test is brutal. That test is brutal. I'm just waiting for everybody to get situated here. I just went live about 2 minutes. I like to give it another minute or two before I get started. How's everybody doing? You all having a good Sunday? You all enjoying your quarantine in your respective states or countries? How's the quarantine situation? Is it being lifted in where you are? Kentucky has implemented a plan to start opening up starting tomorrow, May 11th, and we're going to go through May 24th, and by July, we should have gatherings. I think the governor said of up to 50 people by the month of July, so that's going to be interesting. Outdoor theaters are open. Yeah, I saw that, Kim. In Florida, I think, right? You're from Florida, aren't you, Kim? I forget. Not in Massachusetts. Massachusetts is closed. Some people don't quarantine. Phase 1 started in Florida. Illinois? Okay, Kim. For some reason I thought you were... Yeah, Florida started its phase 1, I heard. What was that one state? Wisconsin? Was it Wisconsin, the one that just reopened, or Minnesota? Reopened and closed right back up after the governor saw that the numbers rose or something like that? I forget which state it was. Not Michigan. It was somewhere out west. Or northwest, I can't remember. There was one state that opened up, and then there was like a spike the day after they opened, and there was a big fuss, and everybody was like, "Oh, we got to shut down." I guess I don't know. I forget which state it was. I can't remember off the top of my head. Not Wisconsin. I think you're right. It's not Wisconsin. Anyway, whichever one it is, good luck to them all. Good luck to them all. Hey, Dog Mom. We got some speed traps, Elena. We got some speed traps in Kentucky that I saw. Yeah, don't forget to smash that like button, subscribe, and comment if you haven't already. We got some speed traps. Not as many. Some counties are a little bit more prevalent than others in the speed trap situation, the speed trap camp. But hey, Bob. Good to see you here, my friend. Thank you, Dog Mom B. Says hi too. North Carolina is out in full force. Nice. That's good to hear. That's interesting. How do I feel about sovereign citizens? I made a video on it. I'm a chick. Check out my channel. Hey, Stevo. All right. We've been live for about, what, 5-6 minutes here? I think it's time to dive in. What do you say? Shall we dive in? All right. So, first and foremost, thank you all. We just keep on climbing. This is crazy. 26,000 subs. I think I just hit like 26,300 or something like that. It's amazing. You guys are the best. Like, literally just incredible. I don't know whatever it is that I'm pumping out. Like I said, I'm going to keep doing it. Obviously, I'm running out of material. You saw I even put up the video of the pro se litigant, and some of you have already inquired, and I'm going to tell you here on live stream. I had to take it down, and I can't tell you why. So that's that. We will not be seeing that video again. But I would still have some videos in the pipeline, which I will be releasing. I just decided to kind of shut things down for a little bit, just so that I can get the algorithm. I think there's a key. There's a key to the algorithm that I think I'm starting to kind of get a whiff of, to the YouTube algorithm, and I'm trying to kind of learn how to use it better to my advantage. So it's not you guys, it's not anything else. It's just me playing around, trying to figure things out. I mean, I could be wrong. I could be completely dead wrong, and I have no clue what I'm doing. But unless you test things out, you're never really truly going to find out. So that's what I'm going to do. I'm gonna test the algorithm and see what I can come up with. So you should expect a new video this Thursday, May 14th. That's the game plan. This Thursday, May 14th, I'm gonna post a new video. And hey, Bob, thank you for the coffee, my friend. Cheers for the $4 donation, brother. Jeez. This is not coffee, by the way. This is hot cocoa, but whatever. Same difference. Just the lack of caffeine. So yeah, courts are supposed to have a soft opening in Kentucky, is what I keep hearing, on June 1st. I mean, I don't know if that's going to play out. There's so much conflicting information out there. It's hard to figure out what is actually going to happen one way or the other until we actually hear from the Supreme Court themselves. And if we do, it's probably going to be this week. It seems to be the trend. They sent it somewhere around the middle of the month. They did that in March. They did that in April. So I anticipate if they're going to close for June, we're going to hear about it somewhere between the 13th and the 15th of May. That's what I anticipate. And Richard Edwards with the $10 clutch lunch donation. Heck yeah. Thank you, brother. Really appreciate it, man. So yeah, the courts should open. They may not. Who knows? Every state's different. Like I said, Kentucky has this plan in place. I already said that the courts have designated a task force for reopening our court system. So how is that going to go with the 6 feet apart, no more than 10 people in one location? I mean, think about it. Think about it. In a courtroom, who do you have that is absolutely mandatory that we cannot do without? At least in Jefferson County and most other counties, really, when you really think about it. We got the judge. We got at least 1 or 2 bailiffs, so that's, let's say, 3 people. A couple of clerks, that's 5. And lawyer-client, that's already 7. You got 7 people already. And then if you're going to include anyone else in the courtroom, I mean, 3 people. And if you're trying to pick a jury, you've just made it completely impossible. So trials, it's very possible that the courts may open with very, very strict limitation, but the jury trials are going to continue to be postponed. It seems to be universal. Lawyers have been talking, obviously, amongst ourselves, and we're seeing a trend that it's very possible that even if the courts open, the jury trials are going to continue to get postponed, because in order to pick a jury, you have to have anywhere from 20 to 40 to sometimes 60 people in one room, depending on if it's a district circuit court case and if it's including federal as well cases, and depending on which part of the country or the state you're in. So jury trials are probably going to be postponed. This seems to be the universal word out there. The jury trials may not even happen until the end of the year. But even after they're picked, the problem is 6 or 12 people, they have to be seated in the same room. There is no protocol in place for the courtroom for them to be 6 feet apart. I mean, that's impossible. I mean, it is possible in some courtrooms it's not. They're going to be seated all the way in the pews. There may be hearing problems. I mean, it's just it's going to be crazy. I don't know how they're going to play it out. I don't know what the. I mean, eventually the social distancing is going to be a little bit more relaxed, and I think that's when jury trials are going to start happening, in my opinion. So it's really hard to say. So I don't know. I can't really predict the future, and we'll see how it goes. Do I prefer more people on my jury? You can only pick so many. In district, it's 6. In circuit, it's 12. The more to pick from, the merrier, of course. So, but judge trials, I think I already mentioned in one of my previous live streams that there was a case in Texas that it was a bench trial, meaning by a judge, no jury, and it was conducted via Zoom by the attorneys. So, and I think it was a civil trial too. So don't forget, it was civil and it was to a judge or something. I mean, something like that. Maybe it wasn't civil. Now I feel like I'm misspeaking, but regardless, it was. I'm like 99% certain it was not a criminal case, and I know that it was without a jury because that would be a disaster. And plus, there's so many things I know as a trial attorney that if you catch the witness doing, I mean, on the stand, you're able to see more body language. You can assess the situation better. You can assess the witness better. It's going to be very, very difficult and very, very unproductive, I feel, even for the prosecutor as well. In a criminal trial, I can foresee a witness maybe reading something from a piece of paper that has been prepared or from their screen. And there's so many different rules you can violate, and you will not even be able to catch it as the defense attorney if there's no camera or if you don't get to see the witness directly in front of you. Again, don't forget to like this video, comment below, subscribe to the channel if you haven't already. Thank you for all of those who have. Let's see. All right, so let's dive in. I see questions. I want to save questions for the very end, just so for the people who came here to get this information and get out of here. I don't want to keep you all, so let's dive right in. The topic for today, as you can see from the title of the video, is what effect does a DUI charge have on a license? And of course, we're talking about your operator's license, whether you are a driver, a non-CDL driver versus a CDL driver. We'll get to that as well. We'll touch on that a little bit. But primarily what we're talking about is if you have a license to operate a motor vehicle in the Commonwealth of Kentucky. I'm going to be focusing mostly on Kentucky. We will touch upon other states as well, but primarily I will be talking about Kentucky because that's where I practice. Now, for all of you sovereign citizen aficionados out there who are about to start arguing, well, this is not driving, this is traveling, this is not operating, this is, in the course of, I'm a settler, I'm not a citizen. None of this matters, okay? We're simply talking about the ramifications of a DUI on your driver's license. So, the main question, this is what, I did a poll, and this is the question you guys want answered. So here it is. What effect will a DUI charge have on my operator's license while the case is still pending? Okay, this is the key. While the case is still pending, Richard the Lion, you're not going to let me speak, man. Thank you for the $20 donation. Holy crap. Thank you, man. I really appreciate that. While your case is still pending, so there you were driving, operating, traveling, whatever you want to call it, around, and you got slapped with a DUI charge. You have not been convicted yet. Maybe you haven't even been arraigned. What happens to your driver's license right then and there, okay? And the most typical answer is nothing, right? In the majority of cases, at the moment you pick up the charge, nothing will happen to your license. When does it start happening? So number one, if you are at the station, okay? If you're at the station and the officer asks you to blow into the device, to blow into his intoxilizer, and you refuse to do so, or to take his blood test, if you refuse either one of those things, your license will be suspended in all 50 states, okay? This is not just Kentucky. This is every single one of the 50 United States, including the non-contiguous Alaska and Hawaii, okay? So if you refuse, you are going to lose your license. Now, the question then becomes, when do you lose your license? There are 3 different ways for that to happen. Number 1, the officer confiscates your license right then and there at the jail, in the jail cell. Before you go into the jail cell, rather, before you go through booking, or booking will take it, and your license will be taken away directly by the police officer or the booking agent at the jail, okay? That's option number 1. I've seen that happen. Option number 2, it will be, if it's been submitted into property, it will be taken away by the property people before you get out. Or number 3, and this is the most common, in Kentucky at least, it will be suspended by a judge at arraignment. Now, Kentucky does not have administrative license suspensions by a special agent of the Department of Motor Carriers. It is done in district court in Kentucky. Kentucky is very unique in this point, by the way. Majority of other states have an administrative hearing that is separate and distinct, sitting with a non-judge who decides whether or not your license will be taken away. That's how a lot of people are able to get their license suspensions reversed and whatnot in other states. Here, you have to argue it to a judge who knows the law, who has been elected, yada, yada, yada. So you have a judge making the determination as to whether or not you get to keep your license. That happens at arraignment. Now, point number 3 may be a little bit separate. What do I mean by that? You may have arraignment tomorrow morning. If you do not get bonded out and it's not a weekend, or in Jefferson County, we do hold court on Saturdays sometimes, and Saturday morning. If you get arraigned on the next day or 2 days or 3 days or whatever, and your license is due for a suspension, it will be taken away at arraignment. Now, it is very possible one of 2 other things will happen. Arraignment could be set for a month from your date of arrest. So you'll be able to drive during that month. An interesting fact happens when a judge writes no driving, which technically by law, you are still permitted to drive until the license suspension order has been entered by the court. So it's kind of like a loophole within a loophole. It's crazy. It's crazy. And unless you actually talk to a licensed practicing attorney, you will never be able to find out if this is actually something you can take advantage of or something you can't. Another option that could potentially happen is the judge may forget, the prosecutor may forget to bring up, I've had these cases happen how many times? The judge may forget to take your license away at arraignment, and then you get to walk out of that courtroom with your license, even though it should be suspended, and they get suspended 6 months later when the prosecutor suddenly realizes, oh crap, I forgot to suspend this person's license, and then they suspend the license at the next pretrial or whatever, 3 pretrials later. Another scenario that is not that uncommon, I just lost my train of thought. I thought I had it. What could happen is, even if your license doesn't get taken away at arraignment, and it doesn't get taken away later on, you could still lose your license if you get pulled over and you shouldn't have been driving. The officer will charge you with, there will be a new charge. You'll be charged with driving unsuspended, and you will lose your license because it will be confiscated since you've been operating on a suspended license, unless you're an out-of-state driver. If you have, let's say, a Florida license, you're driving through Kentucky, your license is suspended, the officer will usually not confiscate the license, and you will be able to keep it, even though you'll be charged with the driving unsuspended. So, now that we've covered that area of the law, let's talk about refusing. So, very important, and I talk about this all the time, refuse everything, okay, including that test, and I will get to the nuts and bolts in just a moment, but in order to make the best case against the state, do not give them free evidence, because that's all it is. There's the whole argument is it in violation to seize your breath or your blood? Is it a violation of the Fourth Amendment? Pretty much universally, the answer is no. So if you simply say, I'm not taking it, you've just invoked your Fifth Amendment right not to to incriminate yourself, Fourth Amendment right to be free from unreasonable search and seizure. And in Kentucky, unlike some other states, there is no mandatory blood test where the police officer can get a warrant. If there's no physical injury or death in the case, then they can't get a warrant to get your blood. So you have deprived them of the best possible evidence they could have against you. Now, you sacrifice your license by doing so, and in some states, the license suspension is pretty severe. California, Florida, Tennessee, New York, Illinois, Michigan, that I can think of right off the top of my head, are a 1-year suspension, okay? I am not discounting that fact. And these 6 states I just named right off the top of my head, I know is a 1-year suspension of your operator's license, okay? So if you refuse, you're gonna lose your license for a year. But you have just made your case all that much stronger and all that much weaker for the prosecution to proceed against you. So why give them this free evidence again? It escapes me, and people constantly argue on my YouTube videos that, well, go ahead and refuse and lose your license. Yes, that is exactly what I'm talking about. You're depriving them of the best possible evidence. You are sacrificing your license at that, and we will get to how to get back on the road in just a minute. So why do we have these so-called implied consent laws? Because the state does not have a way to force you into a blood or breath test. That is why they have invented this implied consent law. You impliedly consent. What does that mean? You, by virtue of getting an operator's license, you impliedly consent that if an officer of the law, officer of the peace, officer of the law stops you and suspects that you are under the influence of something, you impliedly consent to a test of your breath, blood, urine, etc. So by virtue of driving on the roads of the United States of America, you impliedly consent to do these tests. You don't have to consent, but the law says you impliedly consent. So that means you have to defeat the implication, which is not possible. So by simply refusing, you sacrifice your license. Look, you consented to this because we said that you can't get a license unless you consent to it. So you signed the form. There's no way around that. And now we take your license away because you refuse to cooperate with the laws. No problem. And you go back to the court and you ask for something called an ignition interlock device. What is that, might you ask? It's simply called a blow and go, okay? A blow and go device. It's a device that is attached to the starter in your vehicle, that in order for the vehicle to start, you have to actually blow into this tube that is attached to this device. And this device calculates, do you have any alcohol in your system, in your lungs, on your breath? And if it comes back anything, usually it's 0.02 or lower, or 0.02 or higher, it won't start, which could trigger a violation, by the way. And that's another thing. If you blow into it multiple times and it registers a number, that means you are trying to operate a motor vehicle under the influence. And if it gets reported back to the prosecutor, you can get in trouble and they can lock you up for that, or at least ask to get you locked up. The issue with those devices is they're not foolproof, but at least it gets you back on the road. And if you don't, you got to be careful with gum, Listerine, de-icer. I've heard even Monster energy drinks will trigger that. By the way, don't forget to like this video, comment below, and subscribe to the channel. Hit that notification bell if you haven't already. Thank you all for those who already have. Where was I? Yes, the blow and go. So if you refuse the test at the station, you get your license suspended at arraignment. You can ask, in I think in most states, the absolute majority, I would venture to say 4 out of 5, which would be 80% at the very least, without doing any research whatsoever, you can probably petition for an ignition interlock device. Now, in about 15 or 16 states, maybe it's 12 now, it is a criminal offense to refuse the test. So I know Bell, if you're Bell Island, he's an attorney out of Nebraska. But if Bell Island, if you're watching this, Bell, he wants to rip my head off right about now, because Nebraska, he will say it's better to blow than to refuse and attack the machine. Some other states, like I believe West Virginia, it's either West Virginia or New Jersey. It's New Jersey. In New Jersey, the only way to win is to beat the breathalyzer. So if you refuse, since you don't get a jury in New Jersey on DUIs, if you refuse, you have just deprived the state of the absolute most critical piece of evidence that they could possibly have against you, which is a number. So that's the incentive. So the implied consent is the incentive. If you don't refuse, you get to keep your license, at least for the time being, until and unless you get convicted. But if you blow over 0.08, guess what? The likelihood of conviction is all that much higher. Defense attorneys like myself, we look for holes in a case. We look for problems in a case. We look for calibration issues with the machine. And a lot of times we find them, but sometimes we don't. So why give yourself that 50-50? Are we going to find any issues with the machine where you can deprive them of the case in its entirety when it comes to the specific number, right? So that's the incentive by the state. So that's why most people plead, and that's why the system works. They want you to plead because that's going to keep gears moving. Once they have that number, they're like, well, look, you're screwed anyway. Don't hire a lawyer because they're going to help you. Plus, maybe you can't afford a lawyer. The lawyers are a lot of money. They're a lot of heartache. They're a lot of headache. This case is going to be hanging over my head for a year. I'm just going to go ahead and plead, and that's what the system is counting on. Especially the quicker you plead, the better it is for them because they get their money, you get your conviction, and they get to move on to the next case. That's all they want. That's all the prosecutors want. And I've always said, if lawyers and pro se litigants, meaning people who represent themselves, will simply set every single one of their cases for trial and want to argue every single one of their cases, and everybody fought their case, if we do this for like a whole year straight, we're going to start getting jury trial dates of like January 2029 by the end of 2020. So the system would get too clogged up, it would get too saturated, would be too many cases, and it would be impossible for the system to operate. So but of course, no one is doing it. It's a lot quicker than just for a lawyer to charge you like $250 or $500. Here, just give me the money, sign on the guilty plea form, and I move on to my next client. And that's how the system just keeps moving. So I also always mentioned, if you are a CDL or if you're a pilot, refusing of the breath test or the blood test carries its own penalties. Okay. Its own consequences, because CDLs are covered by the FMCSA, the Federal Motor Carrier Safety Administration, and pilots are the FAA, the Federal Aviation Administration. If you refuse on those, when you're carrying a pilot's license or a CDL, the problem is you are sacrificing a whole lot more because if you refuse, you will jeopardize each of those licenses. So it is better with those. Those are the exceptions. It's better to blow. Now, we've talked about the breathalyzer. That's the central key aspect, but obviously we all know there's a whole lot more to a DUI case than just blowing into a device. What about field sobriety tests, right? In the United States, I know some states are different, like Canada, New Zealand, Australia. I know a lot of times those police officers in those countries go directly into the breathalyzer or the blood test. What about the field sobriety test that in all 50 states, police officers are trained by the National Highway Traffic and Safety Administration, or NHTSA, to administer these tests to suspects? They involve essentially 4 things at the very least. And then there are some additional tests that they can tack on if they so choose. We got the horizontal gaze nystagmus, the follow my finger test. We got the walk and turn, the one leg stand, and the preliminary breath test. In the United States of America, you can refuse every single one of these tests with absolutely zero legal consequence, other than going to jail. I'm not saying you're going to beat your case on the street by not doing them. You will still go to jail. You're going to jail anyway, whether you do them or not. Officers will very, very often lie on the stand and say, well, I have released plenty of people that have completed these field sobriety tests to my satisfaction and let them go. The officer has absolutely no reason to let you go at that point, and I will tell you why. So again, there's no legal consequence to refusing all of those, what I like to call the dog and pony show, or another lawyer friend of mine called it the Simon Says type game. Simon says, put your left foot in front of your right and put your arms by your sides, right? If you don't do exactly what I tell you, just like the game, if you miss one of these things, bam, that's a clue, okay? And the officer is going to use that as evidence against you in court. You can bet your ass, okay? So refusing those tests carries absolutely no penalty whatsoever, no legal consequence other than simply getting arrested and going to jail. Oh, you don't want to cooperate with me, Mr. Driver or Ms. Driver? Okay, get in the back of the cop car and let's go. Okay. I mean, what can you do? You can't stop them from arresting you. You don't want to be slapped on with a resisting arrest charge on top of everything else. So what do? Put your hands out. Okay, go ahead. Shackle them. Let's go. Or put them in the back. Whatever they say, right? And by the way, in the Commonwealth of Kentucky, this is just Kentucky now, on a DUI second, third, fourth, or subsequent, if you refuse or you don't refuse, you're still going to lose your license regardless, okay? There's literally zero reason, if this is not your first rodeo, there is zero reason not to refuse because you're going to lose it anyway. So the implied consent is kind of meaningless. It's almost nullified, if not literally nullified, in a second, third, fourth, or subsequent offense DUI. Because you're going to lose it anyway, and you can petition, like I said, for the ignition interlock device anyway. Now, things do get a little hairy if it's a non-alcohol DUI. I do realize I've been talking about alcohol a lot. Some judges will not issue ignition interlock devices on a first, second, third, fourth, whatever, if it's a marijuana or a prescription or non-prescription drug DUI for obvious reasons, because the device is only designed to detect alcohol. So if you got picked up for suspicion of operating a motor vehicle under the influence of marijuana, and then you go back and try and argue, Your Honor, I should be allowed to drive, the state has passed the law that allows me to have an ignition interlock device installed in my car, yada, yada, yada. It may not work. Some judges, and I've run into this myself, some judges will say, look, this was a marijuana DUI, buddy. I am not giving you an ignition interlock device because it's, sure, you're going to drive completely sober, but the problem is you're going to smoke a joint and get behind the wheel of the car, and the device is not going to detect it. And that's actually true. That's actually true. But a lot of judges overlook that, and they don't mind. They will still issue, because the law does say unequivocally, it doesn't say unless it's a marijuana DUI, or unless it's a prescription drug DUI, or unless it's a da-da-da DUI, an under 21 DUI, or an under 18 DUI, or non-aggravated. There's no restriction. There is no restriction. It's still within the sound discretion of the judge. It's not mandatory. And that's where a lot of these judges take into discretion, and they say, look, this was a marijuana DUI, or this was a prescription drug DUI, so we're not going to allow your client to install the ignition interlock device. And I pretty much have no leg to stand on at that point. We all know who those judges are, and I obviously I don't make that argument in front of them. But luckily, they appear to be few and far in between. Thank you, Willie Czar, for number one. Yes, the thumbs up. Absolutely. Free legal advice is worth more than that. I'm just doing my usual spiel, Willie. Welcome to the channel. Thank you for the $12 donation, buddy. I'm gonna drink to that with my hot cocoa. I have some chocolate here too. I'd share it with you guys, but I don't think I have enough. And plus, you're also far away. So there's no reason not to refuse a DUI. I'm sorry, refuse a breath or blood test if you're on a second, third, fourth, or subsequent DUI here in Kentucky. Now, we've talked about what happens if you are charged with a DUI. Now let's talk about what if you're convicted of a DUI, okay? So first and foremost, there are two ways to be found guilty. Either you plead voluntarily, or a jury or a judge finds you guilty. Those are pretty much exclusively the ways that could happen. You could plead in some states nolo contendere. Kentucky is not one of those states. You could plead pursuant to Alford. An Alford plea is exactly the same as any other plea, except you argue that even though I'm innocent, I believe there is so much evidence against me that I will never be able to convince a jury of my innocence, so I'm just going to plead guilty. So it carries the full functionality of a guilty plea, except you get to tell a cute story to any employer in the future. Look, I pled just because I thought that I couldn't win. And there are some judges that will refuse to accept Alford pleas, believe it or not. They will refuse to accept Alford pleas, and it's crazy. It is crazy. But essentially, a DUI in Kentucky will stay on your record for 10 years before you can get it expunged. And if you have an old DUI, you have to wait 10 years to take it off your record. It will stay on your driving record, though, the federal one, for 5 years, 3 of which it can have direct consequences on your ability to maintain operator's insurance, car insurance. So some states, Kentucky is not one of them, but some states are SR22 states. And SR22 is a special form that you have to fill out as an operator of a motor vehicle applying for insurance in that state. In order to be able to drive, you have to have the SR22 form filled out. Kentucky is not one of them, so I know I have very limited information on the SR22 personally, so I will not get into that that much deeper. Oh my goodness. Thank you, Red and Grimmy, for the $20 clutch donation. My man. You guys are awesome today. Thank you. So SR22 is in certain states. Kentucky is not one of them. So like I said, I have very limited information on the SR22 and how it works. Obviously, I can tell you, you are going to have to pay a whole lot more for your insurance, regardless of whether you're an SR22 state or not. You have a DUI on your record, and that makes you a much more of an at-risk driver. The insurance rates do not go up unless and until you're convicted, because we, God bless it, live in a country where you are presumed innocent until they prove you guilty. Sometimes it doesn't feel like it, especially in DUI cases. We in the lawyer world like to refer to DUIs as the DUI exception to the Constitution, where you are presumed guilty, and then you have to prove yourself innocent, especially if they have the number against you. So that's definitely the downside. But it stays on your record for 10 years, on your driving record for 5. That's federal. 5 years is federal. The 10 years is just in Kentucky. Certain states, you cannot ever get it expunged. Like Texas. Texas has a infinite look-back window. I don't believe you can ever expunge a DUI in Texas. The look-back window is infinite, so if you got a DUI in 1901 and you pick up another DUI tomorrow, you will be charged as a second offender. So stays on your record in some states. In Kentucky, you can get it expunged after 10 years. And if it's an old DUI, like I said, there are ways of arguing, and I have one. I've been successful in certain cases where we've been able to expunge the DUI for when it's less than 10 years. There are special exceptions, and I have to look at each case individually in order to be able to decide whether or not this is one of those cases, which county it's in, who's the judge, what facts do we have, and how old is it, etc., in order to get the case expunged. But for the most part, it's 10 years. But it's got to be older than 5. If it's less than 5, there's no point in even trying it. I get a lot of calls sometimes. Somebody pleads guilty to a DUI, and then 6 months later, they try to apply for a job. The job gets rejected, and they go, holy crap, I should have fought my DUI. And then they call me and say, hey, can we get it expunged? I'm like, no, you still have 9.5 years to go. And then they say, well, is there anything else I can do? And I'm like, well, you had a lawyer go with you to court, and you pled guilty pursuant to the lawyer's advice, and proving that under Rule 11, that the advice you received was improper. I mean, good luck with that. It's extremely difficult. I don't do those types of cases mostly, but some lawyers do. And it's very difficult, especially if you've been represented. It's very difficult to undo a guilty plea. I mean, nearly impossible. So it's harder to find a job. Society is against it. Having a DUI on your record is going to be all sorts of trouble for you. Expungement must be done actively. Expungement is spelled EXPUNGEMENT. It's not like the word sponge, like the sponge that you use to wash your dishes or wash your body. It's expungement, EX, not espongement. I mean, I guess maybe if you're Hispanic, excuse me, can you get something expunged for me, please? I guess I guess if you got an accent, it may sound like a sponge, but no, it's expungement. And in order to get an expungement, you have to actively petition for it. You can't simply have the state automatically do that. Expungement is not an automatic creature that just is activated. Once you're ready for expungement, it clicks in and the case is expunged. You have to specifically file a petition and ask the court to expunge the case. So unless there's one exception, if you're a juvenile and you have been charged with a crime and convicted of a crime prior to your 18th birthday, this is called the process of sealing. Once you turn 18, the court will usually seal your record and it will not be accessible to anybody, usually. But again, expunging it would still be a separate process. Now, certain offenses, I know DUIs, like I said, are 10 years. Most other offenses are 5-year expungement statute. If you don't get convicted for 5 years, you're going to be able to get the case off your record. Now, unless it's a felony, unless it's a Class D felony, which some of them are expungible, I think about 61 of them. But if it's a Class C or above, or any of the D felonies that are not eligible for expungement, then you cannot expunge those at all. Some convictions, like marijuana convictions, if you complete a marijuana education program, you can get those expunged pretty quickly. Now, the loss of license, if you refuse on a first offense, if you refuse in Kentucky, you will lose your license for 4 months, okay? If you are convicted, you will lose your license for 6 months unless you install the ignition interlock device, unless your case was not an aggravated DUI, in which case you still lose it for 4 months. Then the ignition interlock device becomes optional unless it's an aggravator, in which case it is mandatory. Another operative thing here, some courts in some counties do not, even though it's mandatory by law, they will still not make it mandatory for you to install it. So that's kind of nice. But it's all jurisdiction based, whichever county that you're in. Now, on July 15th, the law in Kentucky will change. It is gearing towards making it more heavy on getting people to install these devices. It looks like the state has really, really done a lot of good business with Intoxilock and Smart Start and all those other companies. And now the suspension period, it's going to be flipped now. 6 months suspension if you do not install the ignition interlock device, or a 4-month suspension if you do. A CDL is a commercial driver's license, Elena. So 6 months if you not install the device, and then it's shortened to 2/3 of that if you install the device. That law is coming into effect in 2 months and 5 days. So now the ignition interlock device is almost incentivized for people to install. If you hired private counsel, you're going to have to pay for the device outright. But if you're indigent, about 1 out of 5 people, the Intoxilock and the Smart Start people, will accept people into the program for free. But that's pretty much only if you represented yourself or been represented by a public defender. With a lawyer that you've paid for, I've never made that petition because it's impossible to prove. How could you have afforded a lawyer and now you can't afford this thing for $50 a month? I mean, it's fairly cheap. I'm not saying everyone can afford it, but relatively speaking, if you hired private counsel, obviously you have money. So that's an option for some people who are qualified by the court as indigent. Now, the ignition interlock device allows you to get back on the road immediately, as soon as the suspension kicks in Kentucky, as long as the judge grants it. With the coronavirus situation, it's been a little bit difficult for a lot of us lawyers. It has we've been petitioning for a lot of these ignition interlock devices for a lot of these judges, and it's very difficult sometimes to get a judge to do something, especially when you're not physically in the courtroom, because they just set it aside, they put it on the back burner, and then you don't hear from them for 2, 3, 4, 5, 6 weeks. And it's just very frustrating sometimes. It's been very difficult when you can't simply physically be there in the courtroom with the piece of paper, getting the judge to sign that piece of paper right then and there in the courtroom. Hello, Servento. Thank you for subbing. Again, don't forget to like this video if you haven't already, comment below, and subscribe to the channel. Hit that notification bell if you haven't already. Thank you if you have. So, finally, getting to the topic I think everybody's been waiting for. This guy just said about, 20 minutes ago that I can refuse the field sobriety test without any repercussions, without any legal repercussions other than getting arrested and going to jail. Is that true? And the answer is unequivocally, absolutely yes. And here is why you should. This is a crucial question that's been asked by multiple subs, by multiple people, and I finally want to address it. This is extremely important. The question is as follows. If I am driving and I am 100% sober, but the officer decides, hey, you know what? I think this person may be on something. This person may be under the influence of something. Maybe you have a lisp. Maybe you are not having the best day. Maybe you haven't slept very much. Maybe you're jittery from caffeine. Maybe it could be anything. It could be anything, okay? And the officer simply suspects that you're under the influence and says, come over here and do these field sobriety tests. The answer is you should absolutely refuse them, okay? Absolutely refuse them, regardless of whether or not you have or have not been drinking or consuming any illegal drugs, period. Unequivocally, no questions. There are no penalties. There's nothing that the cop can say to make you do those tests. There's nothing that they can do, that they can throw your way, that you're going to be thrown for a loop and say, oh, I guess I do have to perform them. They never ask. They never say, hey, excuse me, Mr. or Ms. Driver, do you mind come over here and performing field sobriety tests for me? You will have a right to refuse them if you'd like, but I would ask you that you perform them. That's not how they do it. They say, stand over here, put your head right directly in front of me and follow my finger. That's how they start the horizontal gaze nystagmus test. Or if they start with the other field sobriety, put your hands to your sides. Come over here and put your hands to your sides. Stand on this imaginary white line right here. Even CDL, pilot, regular driver's, it doesn't matter. Great question. Refusing the field sobriety test has no legal consequences anywhere in any book, in any statute. This is the principle on which this country was founded upon. The 4th and 5th Amendments, the right to incriminate yourself by deed and the right to incriminate yourself by word, and to be free from both of those. That is why there is nothing, literally nothing in the Constitution that the cop can say, you know what, unless you waive it, unless you voluntarily come over and say, okay, fine, I will do them for you. Elena, I do not know if this applies to Canada. I would be very careful. Talk to Marissa Feil. It's spelled F-E-I-L. She is in Canada. She can give you better advice than I ever could, because I don't do Canada. I'm not licensed to practice law other than in Kentucky. Other countries it could be way different. But in the United States of America, don't try it out. Elena, do not, warning, do not try it out. First consult an attorney And then don't forget, everything I'm saying at the end of the day is for entertainment purposes only. Sure, a lot of this can be construed as legal advice, but unless you actually have an actual case, for the love of God, please do not attempt these things. I'm telling you, do your own research. But the law, like I said, the law, from as far as I know, and I know for certain in Kentucky, in all 50 states, when it comes to field sobriety tests, refusing them has no penalty. There's nothing to, I mean, think about it. Think about it from a constitutional point of view, okay? Officer asks you to stand over here and walk this white line. You say, "Officer, I respectfully refuse." Well, why are you refusing? I do not believe that these tests are designed to prove sobriety. I don't believe that they're going to show anything. If you're going to arrest me, arrest me. If you're going to let me go, let me go. But I am not doing your tests, okay? When they start asking, well, have you been drinking? Officer, I refuse to answer any of these questions until my lawyer is present. It's just very simple, and people put themselves in a position where they could have had a much, much better situation, a much, much better case, and they just start yammering, and they start going at all these, I don't know. You know what I'm getting at. I'm so frustrated every time I get a case like it. And I'm like, well, I'm just an honest guy. I was just telling the cop how it is. I'm like, okay, well, great. You just made your case all that much worse and all that much more difficult. But hey, I'll take it and we'll see what we can do. Because I've won cases I had no business winning. I've lost cases I had no business losing. It's just the name of the game. It's just the nature of being a professional, and giving it all you've got, and then seeing the results. So why should these field sobriety tests be refused even if you're 100% sober? Because pursuant to the training of the National Highway Traffic and Safety Administration, and if the officer sees but two clues, and you have an opportunity to fail on the walk and turn, I believe there's 165 or 163 points. And on the one leg stand, it's about 97 different points. Think about it. If you get a 163 out of 165, you have failed the walk and turn. A 99.5 percentile, you have just failed the walk and turn, according to the National Highway Traffic and Safety Administration training. How insane is that? How skewed are the results? Think about it. Same for the walk and turn. You got two clues out of the 97. You just got 95 out of 97 correct. And according to the cop, that is a fail. Sometimes they won't use the word fail, but they'll say we saw enough clues to the fact that we've determined that the person is impaired. That's it. Just two clues, okay? What are the clues? If the suspect cannot, this is for the walk and turn. We'll talk about that first. The walk and turn. If the suspect cannot keep, this is all online, by the way. You can look at this up. There are 8 clues. If the suspect cannot keep his or her balance during the instruction, or they start too soon, okay? If they stop while walking, don't touch heel to toe, step off the line, use the arms for balance, perform improper turn or turns incorrectly, or take an incorrect number of steps. Those are the 8. So you step off the line one time and you stop just for a second to catch your balance. That's 2 clues. You just failed to walk and turn, even though you got the other 99.9% correctly. You'll be marked as a fail, okay? Same for the one-leg stand. You got 4 clues. If you sway, use your arms for balance, hop, or put your foot down. All you have to do is just a simple tap with your foot once, and maybe just sway for a second. That's 2 clues. You just failed the one-leg stand. Excuse me. So why give the officer free evidence to use against you? I have done these tests. I went to seminars with the National College for DUI Defense. I've had speakers call me up to be the subject to perform these tests for them as they administer the tests. It's amazing how dead sober you can fail them without even thinking. Even knowing all of this information, knowing what the clues are, your body and your mind, sometimes there's a disconnect. And doing them, when I see a video and somebody performs them with perfect accuracy and the officer is still maintaining that they failed, I cannot wait to take these cases to trial. My first case that I've won, that's the one in Hardin County that's posted on my channel, the 5-minute not guilty verdict. I used the charts. I used the clues that the officer stated that my client had against them. It's a great tactic to actually show the percentages that the jury sees. Oh, the 2 or 3 clues that you mentioned, that's only 1/100th or 1/50th of the entire case. So it's a great tool that lawyers use. I'm sure a lot of clients come to me and say, "Look, I've performed everything perfectly," and da da da. Prosecutors will ignore this every day of the week. The only place where it truly shines, where it truly comes to fruition, where it truly works, is in front of a jury. When you put this case in front of a jury, and the jury is going to be deciding your client's fate, that is your time to shine. That is your time to go into all of the things that I'm talking about. And like I said, not everybody can afford it. Lawyers are expensive. Jury trials are even more expensive. I understand this. I'm just telling you, this is how this information is used. It looks cute on paper, but unless you can go all the way to trial, you are not going to be successful in winning your case despite the hundreds of issues that the officer has committed in the case. Hundreds of problems that the officer committed in conducting his or her investigation. So again, try these at home. Try these tests at home. Have someone grade you. You can find the instructions on the internet. They're very easy to find. Just Google instructions for walk and turn, or instructions for one-leg stand, clues for walk and turn, clues for one-leg stand. Boom, you've got it. Don't worry about you notice I haven't really talked about the horizontal gaze and nystagmus, to follow my finger. It's a little bit more complicated. We should probably, if we're going to do it, I will devote like a separate video to the horizontal gaze and nystagmus by itself. And by the way, I recently learned horizontal gaze nystagmus is a misnomer in and of itself. There is no such thing as horizontal gaze nystagmus. It is a pure creation of the police and the government, and they are going to use those terms like these magical, but essentially it's nystagmus. That's all it is. The horizontal gaze, all it means is it's a finger that's being moved horizontally and you're gazing at it. But there's another term. It's a medical term, and it escapes me right now. It has something to do with nystagmus itself. But horizontal gaze is a fiction. It is a fiction created by the government, created by police, created by the National Highway Traffic and Safety Administration back in the 80s. They created these fancy terms, and now they're being used universally to convict people every day in the court of law. And you may recall my one case out of Campbell County where I got I think it was 45-minute not guilty verdict. I tried to introduce the horizontal gaze nystagmus, or the absence thereof, that the officer never conducted that test, and I started asking him questions about the horizontal gaze nystagmus, and the judge stopped the proceedings and asked me to stop talking about it because they don't allow those tests in that county. So some counties don't even, some states I know don't even allow the horizontal gaze nystagmus to be mentioned in the first place. So it all depends on your jurisdiction. And finally, the PBT, the preliminary breath test. I had an officer on the stand, and by the way, that same case where they said, this thing is not reliable. He said it on the stand. These things are not reliable and they're not admissible in court. I don't know, they were shooting themselves in the foot. He said that she blew a 165, whereas on the video, I think you can hear, or not the video, I'm sorry, in the citation. In the citation, he wrote like a 158 or 159. And then he testifies that it's a 165. And then he says this thing is not even reliable. It's not even admissible by the courts. I mean, it's mind-boggling how these people are just so twisted in their own confidence that they're just going to get that conviction. Nothing else matters. Nothing, and it's sickening. It's sickening, and something must be done about that. But no one ever will. That's why we defense attorneys are the final frontier, the last line of defense against the tyrannical police officers. So this is what we do. So like I said, try these tests at home. Try these walk and turn, one leg stand tests. Have your friend look at you and grade you. Have fun with it. Maybe do it sober, then try with a couple of drinks if you want, and see how well you fare. And I guarantee you will not pass them, pretty much, without even. I'm giving you a test right here, right now. Go for it. Prove me wrong. Video it, send it to me, and show me how on the first try. Don't practice. I don't want you to practice them 50 times and then show me a video where you finally perfected them and are able to do them with perfect precision and accuracy. On the first try, just like on the street, with the level of stress, turn on some blue-red lights to be shining in your face. Add the element of stress and nervousness of a police officer doing an investigation. Add some cars flying by. Add all these elements, and now for the first time in your life, start performing these tests. Now you see the scenario that I'm painting. It is not only improbable, not just impossible, completely impossible to pass these tests in any shape, form, or capacity. So even if you are truly 100% sober, refuse these tests on the street. Now we finally get back to the blood test, back to the blood and breath test. And now the question is, if you are completely 100 billion% sober, you have no alcohol, you have had nothing to drink, and the officer asks, will you blow into this device for me? Well, if that's truly the case, would I trust the officer? Maybe, this is the only exception I will ever speak of. It may be a good idea to blow. If you really truly trust this device, and I still don't to this day, even if I had not been drinking, which I don't, most of you who already know me, who are regular viewers of this channel, I don't drink. If an officer puts a PBT in my face, I am going to refuse it. Mark my words. I am going to refuse it because I don't trust these devices. I don't trust these suckers, what they can fiddle around with it and do with it. I don't know. I don't know what they're capable of. I don't trust them. So when people ask me, should you refuse if you're 100% sober? I would say, yes, you should. But even if you do, and he takes you to the station, and at the station, he asks you to blow into the device at the station, and you register as 000, guess what he's going to do? I want you to submit for a blood test now. I want you to submit to a blood draw. Now, if you refuse, it doesn't matter if you submitted to the breath test. The blood test is, if you refuse the blood test, you're still going to carry the same penalties for refusing as if you refused the breath test in the first place. So now you have to get your blood drawn. And now you have to be careful. Are you going to submit to a blood draw? Should you submit to a blood draw? Well, let's see. Do you take any prescription medications that could potentially show up? Are they within the therapeutic limits, even if you do have a prescription for all of them? Do you take Adderall? Are you prescribed Adderall? Did you take your buddy's Adderall a couple of days ago that may still be in your system? Other amphetamines? Have you eaten anything that could potentially show up as positive for drugs, like poppy seeds? They'll show up for what's that drug called? Not peyote. Is it peyote? I forget. The poppy seeds, they'll show up as positive for the hallucinogenic drug. If you have ingested, smoked, inhaled marijuana in the last 30 days, it will stay in your system. If you're a heavy user, opiates, thank you. No, it's not opiates. It's definitely not heroin, Elena. Elena, you're a troll. We got a troll in our midst. Opium, yes, opium. That's the right word. Thank you, Hoki. Opium. So poppy seeds, they'll show up positive for opium, the hallucinogen. So if you've ingested or smoked marijuana in the last 30 days, it may stay in your system, especially if you're, like I said, if you're a heavy user. So if you're a heavy user, it may be stored even longer. So even though you haven't done anything and you give them your blood and you leave the jail and you go, oh, shoot, I smoked weed with my buddy 2 weeks ago. Is it going to show up? And if it does, guess what? You are 100% sober driving. The blood comes back 0.0 whatever nanograms per milliliter of THC. Guess what just happens? Without hiring an expert, a lawyer, taking this all the way to trial and trying to convince a jury, which is very doable with those three things, but you're talking about at least 10 grand invested just to show that this joint you smoked 3 weeks ago stayed in your system and the jury should acquit. And you will still win, but you cost yourself a year and a half of your time and at least 10 grand in Kentucky. Some states probably even 15 or 20 or 25 grand. So that is basically my spiel. For the most part, universally, refuse, refuse, refuse in summary. Refuse, 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 refuse everything. And the exceptions are if you're CDL or pilot, don't refuse the breath test at the station. If you're 100% sober, be careful not refusing the blood draw because of the drugs that may still be in your system from days or weeks past. And I mean, for the most part, just be respectful. Just be respectful with the police officer. Maybe they'll let you go. If you can get a lawyer on the phone, somebody asked if I answer the phone 24/7. I used to when I was able. Now I value my sleeps more than I value money. And sometimes it's difficult at 3 o'clock in the morning. I used to sleep with headphones in. So if you rang me at 3 o'clock in the morning, I would actually physically answer to try and capture those calls when I was younger. I can't really afford that anymore. I need my rest. But I do have an answering service, and they'll capture those leads. They can't give legal advice, obviously. But when I capture those 7, 8, 9, 10, 11 p.m. phone calls where they are just got booked at the jail and they're looking to hear from somebody, should I refuse or should I submit to a breath or blood test, then I will tell them, refuse, absolutely refuse everything. And yeah, stress is why my hair is gray. I got the salt and pepper going on. Thank you, Elena, for pointing that out. I love my hair. It's I think it's very making me look a lot older than I am. Earned me clients that probably thought I was way older. I've gotten, when I was younger, I think I was 28. One time I asked somebody who how old did they think I was, and I think they said like 38 or 40 or something. So it added like 10 years to my age, which is phenomenal. Only 10 minutes to call a lawyer, Richard. That's because they don't want you to sit there and bug them forever. They don't want you to sit there and bug them forever. And I just turned 32. I just turned 32 on Tuesday, May 5th, Cinco de Mayo. Woohoo! Both mine and Beatty's birthday. That video is on YouTube. Feel free to check it out, you guys. So this is pretty much it for the lecture portion, I guess, let's call it. And we can dive into questions. Taco Tuesday. Yes, thank you, Hokie. Thank you, thank you, thank you. All right. What made me want to become a lawyer? I always wanted to help people. Hugh. So feel free to chime in with your questions. I'm gonna eat some chocolate and drink some hot cocoa. While you guys are getting those questions to me. I'm sorry, you guys, but I'm unsubscribing, says Aline. I'm a pharmacist who enjoys the channel. Obviously, a DUI guy doesn't appreciate good company. I'm not sure what I said. I was talking about Elena, not Aline. Elena Banana Canada. So I'm sorry, Aline Whitaker, if I have offended you in any way, but I wasn't even talking to you. But unsubscribed and unsubscribe. Don't forget to like this video, comment below, and subscribe to my channel if you haven't already. So what's the advice to counter the field sobriety tests on medical grounds in trial or pre-trial? Just don't do them, and you don't need to contest them. Thank you, F. Lotog, for the clutch 2 $5 donations. During a previous live stream, you said one of the reasons why you believe police have too much power is police have complete discretion on the street. Do you believe this can be detrimental for suspects, defendants? Absolutely. I mean, their discretion is going to hurt you because they have complete authority and complete power. If so, why? Can you provide an example? I mean, them telling you here, provide the field sobriety test, they have complete discretion in deciding how to grade them, where the clues are. Even if the clues don't exist, if they don't have a body camera or a dash camera, you have no way of disproving, wait, this never happened. This is not how it happened. This is not what I said. This is not what I did. They can fabricate the entire complaint and then lie about it through their teeth at trial, and you have no recourse, no repercussion, and you have to fight against the lying cop. I mean, why? Why put yourself through that? Do I have a case that I'm most proud of? I have lots. That's going to be a separate stream on that, Caleb. How would you even go about contacting a lawyer after hours? It's very difficult, Mark. It's very difficult. There's no answering service that's attorneys only. Do I like dogs or cats? I like animals, period. Weibel777, it's not complied consent, it's implied consent. Implied consent simply means by virtue of the state issuing you a driver's license, you have impliedly consented to any test of your breath, blood, or urine, or any combination of those tests if an officer of the law suspects that you are under the influence of something while you're operating a motor vehicle. So you impliedly consent to those tests by getting a driver's license. Bring out the dog. She's out resting. Beatty is her name. If I decline the test, will they search my vehicle? An officer needs probable cause in order to search a vehicle. If they don't have it, they can still search it. It will be illegal, and you'll be able to suppress it pursuant to the Fourth Amendment. But all an officer has to say is, I smell weed, and that's it. Boom. They just magically created probable cause to get in your car. So if you decline the test, will they search your car? Maybe, maybe not. Can you refuse the breath test, asks Michael, and insist on a blood test? No. I've had cases where people do that, and the law in Kentucky says universally you cannot. It is officer discretion. Again, see, there's the power, F. Lotog. There's the power that I've been talking about. You can't even say, look, take my blood, a much more invasive liquid that could contain anything and everything. But I refuse this breath test. You can't do it. You cannot use that as a tool. The officer has complete discretion in Kentucky at the very least, probably other states as well. Where are police power derived from? The government. I don't know. Create a 1-800 line with instructions not to answer questions. Yeah, but that's risky, Gypsy Heart, because what if, again, what if they're a CDL driver, and how would they know to call that line? It creates too many gray areas. What's the sense of being sworn in if they're going to lie? I mean, welcome to the modern world, Rocky. You swear to tell the truth, the whole truth, and nothing but the truth, so help you God, and then you just lie through your teeth. Why do people have lawyers on retainer? Hugh, that's a little bit of a complicated question. I'm not sure what you're asking here, but why do people have... If you need somebody, probably won't be with a DUI lawyer unless you plan on going out, getting drunk, and getting arrested. So you would just want to make sure that this lawyer knows ahead of time, which would be the dumbest thing anybody has ever done. I don't know why you would do that, but let's say in a business law situation, you would want to have maybe a lawyer on retainer in case something happens. They're already paid. All you have to do is give them a call like, hey, I am trying to open up a second location. I'm running into issues with the government. What do I do? And you've already paid them. So they have to put that retainer in a separate bank account. and from that account, once they've completed the work, they can withdraw the funds. So it's not technically earned, and you can still get that retainer back, unless you are talking about just a hiring retainer, meaning a retainer is just to get paid upfront for services you're about to perform as the lawyer. So two different types of retainers. There you go. Why can't police who lie be held responsible and fined or fired? Just because there's no protocol for that to actually happen. There's nothing on the books, on paper, to allow for, or a tool, if you will, to allow for that to actually happen. When I lose a case, do I look back and analyze? Absolutely. I think that's a fundamental precept of doing anything in life. When you lose, you try and analyze it. Sometimes my chess games, I'm so embarrassed about losing a chess game. I'll be like, I don't ever want to look at this garbage again. Like, it's probably bad. I probably should, but sometimes it's just too annoying to look at. So, but yes, I try to analyze a lot of my cases and try and figure out why did I lose if I did, and so on and so forth. Have I ever been arrested? No, Elena. For $300, is it worth everybody to just invest in some car cameras? Yeah, absolutely. I actually bought a car camera. I showed you guys the sharper image camera that I bought. By the way, it's not accepting my memory card, so I'm gonna have to see what's going on with that. Probably either return it or get a new one, or just buy a new one. Karen Walker, the nanograms per milliliter of THC that says you're high, I don't know what that is. I know what you're trying to ask. It's just you asked it in a different way. In Kentucky, it is zero tolerance. So anything above 0.00000, you are considered under the influence of. Some states like Washington, it's 5 nanograms per milliliter. You're not considered high, but you're considered under the influence, if that's the equivalent of 0.08 in alcohol terms. Michael Jones, here you go. He keeps a lawyer on retainer because he's got a business. Bye, Magnus. Thanks, Megan. Yeah. If I ever been. I cannot wait for the day that a police officer arrests me for something that I'm doing in court in order to protect my client. You guys may remember that video that went viral of the public defender who was standing. There was, like, I think an FBI agent who tried to video her client or take a photo, and she just stood between them, and they said, "Ma'am, if you don't move, we are going to arrest you." And she wouldn't move. She said, "I'm protecting my client's interest. I'm not moving." And they arrested her, and they put her in handcuffs right there on camera. I mean, that would be a day. I think it would be phenomenal. Free publicity, and plus it's an embarrassment to the department for arresting a lawyer for trying to do their job. Some of the prosecutors in my videos look a little old to be prosecuting misdemeanor cases. They're just prosecutors, man. Why are you? Don't be an old ageist. Don't be an ageist. Anybody can be a prosecutor at whatever age. Just let people do what they want to do. Can you use your own dash cam video in court sometimes? As long as it's admitted properly? Absolutely. Oh, hey, B, how's it going? Now we got 2 mods in the house. I don't know if Kim is still here or not. I haven't seen her comment for a while. I do civil rights cases as well. Car accidents and so on. And I'm wearing pajama pants. Do you know when you're going to win a case while it's happening? It depends, Mark. Memory card is too slow. Need a bigger one. This one is like a 64 gigabyte. Are you kidding me? It needs something better than 64 gigs? Or is it too slow? I don't understand these technology things. Sometimes it feels like I thought it was pretty tech savvy, but this is a SanDisk Extreme Plus 64 gig. Are you saying it's not enough? It's not that it's not enough memory, but it's too slow. I'm not sure what that means. I'll have to look it up if it's too slow. That's news to me. Have I ever received feedback directly or indirectly from cops that may look bad in the case? Yes. One of your examples was an officer lying on a report. F. Lotog, thank you for the $5. Sorry, I thought I called it out. Wouldn't it be more an example of misconduct and less of an example of officer discretion? Well, it's hard to prove sometimes because, again, you only have one side of the story unless I have a video that directly contradicts, which is a golden moment. Just simply the officer saying one thing, my client saying another. Go prove that the officer is the one lying, right? Cards have a speed rating. I'll have to check it out. I'll have to maybe put in 128 gig. I don't know if that's the issue. But whatever, I'll figure it out. It does not record directly to the cloud. It records locally, Richard. I may just buy a new camera. I don't know. This one seems a little poor. Poor quality. All right, we're coming up on an hour and 21 minutes here. It's the speed. Okay, so I don't know. What's the speed rating on the SanDisk Extreme Plus Micro SD XC version 30382? I don't know. Can you guys see this? This is the card. It's going to be so blurry, probably. Yeah, the text is too small. You can't see it. I don't know what the speed on it is. It's red and gold. SanDisk Extreme Plus. The speed is fine. It's probably the camera. I don't know. It was made in China. So anyway, unless there are any other questions, I guess we're gonna end the stream on this. What class is it? I don't know. Does it say it on here? Made in China. I mean, that's the class, right? That's the class. XC. Is that the class? I don't know. When do your rights stop? When somebody sets the Constitution on fire, Donnie. And sometimes it feels like the government already has, looking at the stuff that we've been seeing recently. I mean, police officers arresting people for swimming in ponds, walking their dogs in parks. It's just embarrassing. But I can't wait to see us when we start litigating these cases. It's going to be crazy. Going to court, Your Honor, we ask that our client's case be dismissed. She was jogging with her dog through the park. What's the basis for your argument, counselor? She was jogging with her dog in a park, Your Honor. Oh, I'm sorry. I didn't hear you say that. Case dismissed. I mean, can we switch lawyers in the initial phase of a case? Yeah, Vic, you can switch lawyers typically without any repercussion other than the money you've already spent. Probably you won't get it back. I will take all of those cases, CFW, Carolina. Bye, Elena. All right, so I see no additional questions. I think we are We have pretty much come to the apex of the stream. So don't forget to like this video, comment below, subscribe to the channel, hit that notification bell if you haven't already. Thank you all for everyone who has been here with me today and who has subscribed, commented, liked, asked questions, etc. I do cases in Kentucky and Indiana now. Vic, I'm trying to break into Ohio by the end of the year. I don't know how that's going to go. Thank you all once again. Thanks for coming. Thanks for joining me on this Sunday night. Sorry I couldn't stream yesterday. I will stream next Saturday, May 16th at 6:30 p.m. Eastern Time. We are going to be talking about a very interesting topic. Once again, the constitutionality of DUI checkpoints. The constitutionality of DUI checkpoints. So join me in 6 days, Saturday, 6:30 p.m. Eastern. I will also premiere a new video on Thursday, May 14th. So this Thursday, in about 4 days, I'll premiere a new video. And I thank you guys once again for joining me, and I will see you all next Saturday. Bye, everybody. Have a good rest of your weekend. Bye-bye.